Hello learners, in this video we will be dealing in with patentability criteria. Brief introduction about myself. I'm a lawyer and a patent and trademark attorney. Prior art search, the most important search which an applicant or an inventor should make in order to verify whether the idea which they are working upon or the invention they have come out with is eligible for a patent or not. It gives clarity. And if that's the search is made at the inception of the idea only, it saves lots of time and money in case that subject matter has already been worked upon and patented in any part of the world. Then when you file an application to the patent office also makes a patentability search whether all the criteria of patent is being fulfilled, whether the invention is patentable as per the law of the land. Once they approve your application, then you get the patent, then exclusive rights to exploit that invention. You become the owner, and you get that. Patents are generally said to be negative rights because it debars the others from using those of your rights. There are steps which are required to be followed to file a patent application are: first is drafting a patent application. You have to draft an application. If your application is still not ready, your research work is still not ready, you will file provisional application. Application is generally referred to as specification. You will file the provisional specification. If your invention is all ready to you can bring it to the market, then you will file a complete specification giving all the specification, all the details. And claims part should be included in the complete specification. In provisional, it's not mandatory that claims should be there. Filing the patent application should be done along with few forms which are required to be filed. Then comes the publication. After you file an application, the application will be published in the public domain in a journal. So it comes to the public domain. After publication, again you have to make a request for examination. After examination, the examiner will give the examination report if any objections are there. If not, no objections are there, then simply patent will be granted to you. The examiners at the patent office examines your patent application. Patent application is examined to ensure it meets the criteria of patentability. If it meets the criteria, the patent is granted for 20 years. The key criteria for an invention to be patentable under Indian Patent Act are novelty, non-obviousness or inventive step, usefulness, industrial applicability, should not be excluded under Section 3 and 4 of Indian Patent Act, and full disclosure. Relevant sections have been mentioned along. Under Section 21J of the Indian Patent Act 1970, an invention is defined. Invention means a new product or a process. It can be any device, it can be any process, it can be any composition of matter, and it can be an improvement with what is already been existing. You have just made some small changes and resulting in some technical advancement or more economic significance compared to earlier. So it should involve an inventive step. Inventive step, who will decide that it involves an inventive step? So here we'll see from the perspective of a skilled person in the relevant field to which the invention is related. In the relevant field to which the invention is related to, we will see the perspective of the skilled person, whether it is obvious to that skilled person he can work around. It's very easy for him to work around it's then we'll consider that the invention is not new if it is obvious to that skilled person. If it is not obvious to that skilled person, then only we can say the invention is new, the product is new, process is new, because it's a normal skilled person in that relevant field cannot think of that. And the third is that it should be capable of industrial application. The invention, process, product, anything which has been invented is capable of being manufactured and used for the benefit of the society. Novelty. Means what novelty means? That it should not have been disclosed in any form. It shouldn't have been published. It shouldn't have been used anywhere in the world when before the filing of the patent application. If it is published, if it is used after filing of patent application, it is not going to affect you. But if any information is already available in the public domain in the form of publication, or it is being used in any part of the world, then you are in trouble. Probability of getting your patent is very less. This novelty includes not having been published. It shouldn't have been published in any document or used publicly. Inventive step, non-obviousness, it's the same thing. Under Section 21JA of the Indian Patent Act 1970, an inventive step is defined. What is inventive step? It means a feature of an invention that involves technical advancement as compared to existing knowledge or having economic significance. Either it can have technical advancement or it can have economic significance. Compare to what is already in the public domain, compare to what already is existing, or both. It can involve both also. That makes the invention not obvious to the person skilled in the art. It should not be obvious to a person skilled in the relevant field of the technology. We will look from the perspective of a person who is skilled in the relevant field to which the invention is related, whether that person can think of that invention. It's very obvious to him. Yes. If yes, then it is not an inventive step. It doesn't involve an inventive step. But it is not obvious to the skilled person of such invention how to get around, how to get to that invention that is very new for him also. Then we will say yes, it involves an inventive step. It should represent a non-obvious advancement over existing, non-obvious to the person, not to the normal person, but the person who is skilled in the relevant field of technology to which the invention is related. Under Section 2, Subsection 1, Clause AC of the Indian Patent Act 1970, capable of industrial application is defined. What is capable of industrial application? It is in relation to an invention, means the invention is capable of being made or used in an industry. It should have practical utility. In Chiron Corp versus Murex Diagnostics, the court ruled that this phrase should have a broad interpretation of commerce or production and that there should be a financial benefit involved. Invention must not be included under Section 3 and Section 4 of the Patent Act. There is an exhaustive list of subject matters which cannot be patented under Section 3, and Section 4 deals with inventions relating to atomic energy. So, in brief, the subject matters can be categorized as abstract ideas cannot be patented, not technical methods like methods of agriculture or horticulture, medical procedures, certain biological processes, aesthetic creations, discoveries cannot be patented. It should be invention, not discovery. Invention relating to atomic energy. There is quid pro quo. There is reciprocity. If the patent office gives patentee a time-limited monopoly, then in return, patentee has to make full disclosure about the invention. For 20 years, the patentee is getting protection. He has exclusive rights with regard to that invention. That what is expected is in return to the society where he's getting protection, he should make full disclosure of the information relating to the invention so as to, if person skilled in the field to which the invention is related, he goes through the disclosure, he can replicate the invention. It should be it should include detailed description of the invention, including the best mode of execution, how that result can be achieved. The requirement of sufficiency of disclosure under Indian Patents Act 1970 has been statutorily laid down in Section 10 of the Act, read with Rule 13 of the Indian Patent Rules 2003. Under Section 10, it has been laid down that how the information is to be provided if the invention is relating to any biological material, when, where, how the deposit of biological material has to be made, and how the information within what time the patent office has to be informed. So disclosure of each and everything has to be made to the patent office by the patentee to get a patent. It's one of the most important criteria to get a patent. Thanks for watching.